Welcome to Public Health on Call, a podcast from the Johns Hopkins Bloomberg School of Public Health, where we bring evidence, experience, and perspective to make sense of today's leading health challenges. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes.
Hi, listeners. I'm Lindsay Smith Rogers, producer of Public Health on Call. Next week, we're launching Climate Mondays, a series of episodes dedicated to hope and change. Over the next few months, we hope these conversations with leaders working at the intersection of climate change and public health will bring fresh energy and hope to the topic. Big thanks to Shelley Hearn, director of the Johns Hopkins Lerner Center for Public Health Advocacy, for guest hosting this special series. We hope you enjoy these interviews, and as always, we welcome your feedback to our email, publichealthquestion@jhu.edu. Today, a legal update. More than 6 months after the Supreme Court decision striking down a constitutional right to abortion. Joanne Rosen of the Johns Hopkins Bloomberg School of Public Health speaks with Dr. Josh Sharfstein about what's happening in states and at the federal level. She also explains efforts to address other threats to constitutional rights, including the recently passed Respect for Marriage Act. Let's listen.
Joanne Rosen, thank you so much for coming back to Public Health on Call. It was about 6 months ago that the Dobbs decision was released by the Supreme Court, which ended the constitutional right to an abortion and left it up to the states. What have we seen happening over these 6 months at the state level?
It's been a really busy 6 months, and in some ways, predictably so. So at the state level, in the past 6 months, abortion is no longer available at all in 14 states. And it looks like that may be just the beginning rather than the end of state actions to ban abortion. The Guttmacher Institute has estimated that probably 25 or 26 states are likely to ban or significantly restrict abortion. At the moment, in addition to the 14 states that have banned abortion, there are 8 states that have introduced bans that are currently blocked by court order. So there's been quite a lot of movement to ban or significantly restrict abortion in the 6 months since Dobbs.
Now, one of the issues is that the case has sparked legislation and action in states that are supportive of abortion rights. What's been happening there?
Yes, that's absolutely true. On the other end of the spectrum, the states that are really restrictive of abortion, there are a number of states that are 15 states actually, and the District of Columbia that are more protective of abortion. And many of these states during the most recent legislative session, in anticipation of the outcome in Dobbs, introduced new legislation to further protect abortion and protect abortion access. A number of these states introduced protections that would allow doctors who perform abortions to be protected against lawsuits or claims from other states in the event that they perform abortions on women who travel into those states from states that have banned abortion. Maryland was among a handful of states that took steps to increase the number of healthcare professionals who would have the necessary credentials to perform abortions so that those states would have a critical mass of providers who were able to deal with what they anticipated to be increased demand from women who are traveling into these more protective states, from states where there are bans. So there were measures taken in 15 states and DC to try to shore up and protect both abortion access and to protect the people who perform abortions.
Got it. Let me ask you about what lies in between the group of states that is banning or trying to ban abortion and the group of states that is expanding access and trying to protect their health providers, which is the legal gray area of what one state can do to try to limit what happens in another state. What, if anything, has happened to define that gray area? Can a state say you can't travel for an abortion? Can a state make an abortion provider in another state a criminal for doing an abortion? What's the status of that legal situation?
These are still wide open legal questions that remain to be determined. There is no explicit constitutionally protected right to interstate travel. But historically, states are only able to criminalize or legislate matters that take place within their boundaries. So if a pregnant person travels from Texas, let's say to Maryland, to get an abortion, could Texas prosecute her upon her return? Or could Texas prosecute the doctor who performs the abortion? Historically, that would look like it shouldn't happen, but it's still an open legal question, which is why some states have introduced legislation to protect the doctors within their boundaries. But a really important point is that the possibility of a state legislating outside its borders and going after doctors in other states has had a chilling effect in some states. There are doctors, for example, who may be licensed in multiple jurisdictions, including jurisdictions that have banned abortion. They don't practice in those jurisdictions, but those states have said that they could discipline those doctors or could suspend their licenses, even though the services they're providing are lawful in the states in which they're providing them. So even before we get some legal answer on whether states can reach outside of their boundaries, there's a chilling effect and a real concern about what would happen.
So if there, for example, is a doctor who cares for patients both in Texas and, say, New Mexico, and does abortions in New Mexico, then Texas might take away their Texas license and make it impossible for them to practice in Texas, even if they don't do abortions in Texas.
Yes, precisely. And I've heard from physicians who perform abortions and are licensed in multiple states that they are deeply concerned about this.
What about ballot initiatives? I've been reading about ballot initiatives. What's happening there?
Yeah, so as we all knew from the midterms just a couple of weeks ago, there were 5 states that had abortion-related matters on their ballots. So you have to circulate the ballot question, and each state will tell you how many signatures you need in order to get that ballot measure onto the ballot. There were 5 states that had these. 3 of the ballot initiatives were abortion protective, and 2 were really abortion restrictive. The abortion protective measures all passed, and that included a constitutional amendment in the state of California that protects the right to abortion and to contraception. So California is now protected by law, but also by its constitution. And the 2 measures that would have restricted abortion were both defeated. And then even prior to the midterms, there was an election that you may recall in Kansas in August, which was the first ballot measure in Kansas at that point to be considered after Dobbs. And that ballot measure, if successful, would have amended the Kansas state constitution to ban abortion, and it failed by a healthy margin. So ballot measures are another way that voters are making their voices heard.
Let's look at the federal level for a second. I think if the Democrats had kept Congress, then maybe we'd be talking about whether a right to abortion could be written into federal law. If the Republicans had taken Congress, maybe they'd at least be passing legislation to ban abortion. It's conceivable that they could do that. But now we have a divided Congress. What do you think that means?
So the Women's Health Protection Act, which would sort of provide protection for abortion access nationwide, has been introduced in several successive Congresses, and including the last one, and has never been able to get out of the House or to get out of Senate. So I don't know that the future looks particularly in a more divided Congress. I think that's a non-starter. The Hyde Amendment, which has prohibited the use of federal funds for abortions, except in very limited circumstances. There have been attempts to revoke the Hyde Amendment for decades, and those have failed. So I think that a federal initiative to protect abortion is unlikely.
Outside of congressional action, what is happening federally on abortion? Are there steps that the Biden administration is taking to protect abortion access administratively? And are there challenges to abortion that are coming to administrative agencies?
So there is some scope that the federal government or the president through executive order has with respect to abortion. It is more limited. Most of the legislative power resides in the state, but the Biden administration issued guidance under EMTALA, making it clear that in cases where a pregnant woman's health is jeopardized and the appropriate medical intervention to deal with her health, to treat her, involves an abortion, EMTALA protects and requires hospitals to perform those abortions. So this would be most relevant in states that have banned abortion or included very narrow exceptions for the life or health of the mother. And physicians in those states might be worried about the huge ambiguity of whether the condition is sufficiently serious to put the woman's health or life at risk. And so the guidance under EMTALA is intended to make it abundantly clear that if a person who is pregnant and is seeking emergency medical care at a hospital and requires an abortion as part of treatment, EMTALA prevails. It would preempt the state law with respect to very limited rights to abortion.
And if I'm not mistaken, that position of the Biden administration on EMTALA, this emergency treatment law, is being challenged in court by some of the states.
Yes, by Texas and some other states, I believe.
What about on the other side? Are there efforts to try to restrict access to abortion through administrative challenges?
Yes, there have been. So it's really clear at this point that the reversal of Roe was not really the end of the debate about restricting abortion. And the Supreme Court in Dobbs said, without the constitutional guardrails of Roe, the question of abortion is now returned to the people through their elected representatives. But that doesn't appear to be the end of challenges to try to restrict abortion. And there are, in fact, in addition to challenges by organizations who are trying to secure greater abortion access, there are various administrative challenges by those who want to essentially ban it nationwide. There are two recent ones along those lines in particular that both are trying to restrict or limit access to one of the medications that are used in medication abortions. There is a petition that's being filed with the FDA asking the FDA to impose a new requirement on any physicians who prescribe one of the drugs used in a medication abortion. And specifically, they're asking the FDA to require those physicians to dispose of what they describe as fetal remains from medication abortion and treat the fetal remains as medical waste. This is quite burdensome to actually implement if they were to succeed in this, because medication abortions don't take place in clinics or hospitals. They take place in the person's home. So trying to treat the products of conception as medical waste and get the FDA to impose this disposal requirement on doctors would make the use of medication abortion so burdensome that I think many physicians would simply be unable to prescribe it. It's expected that the FDA will reject this petition and that the challengers will then try to review this in federal court. They've argued that the flushing of fetal remains into wastewater presents an environmental hazard. So they're making an environmental protection argument. And again, if successful, which I don't think they will be, it is one way of making it virtually impossible for doctors to comply with the law and prescribe medication abortion. Then there's a second challenge, also very recent, that seeks quite directly to ban one of the medications in medication abortion altogether. And it involves a court action that would compel the FDA to withdraw its approval to mifepristone, this drug. And mifepristone has been approved by the FDA for 22 plus years. So they would like it withdrawn, and they're seeking a nationwide preliminary injunction to prohibit the approval of mifepristone while the litigation proceeds. So those are two recent attempts to try to prohibit access to medication abortion. And as you probably know, medication abortion is the most common method used for abortions in the country, and its use is expected to rise post-Dobbs.
Well, to me, that means, first of all, there may be some additional court decisions to watch, but it also suggests that should there be elected an administration that is committed to reducing or eliminating the abortions in this country, that they may aim for the FDA to try to put in place some of those ideas.
That is absolutely correct. And the lawsuit that's filed in an effort to get the FDA to withdraw its approval There was actually sort of jurisdiction shopping, and the litigants in that case filed their lawsuit in one of the most conservative jurisdictions in Texas. And it's served by only one judge, and that judge is one of the most conservative judges in the country. So just as there may be jurisdiction shopping in bringing a lawsuit, you're correct that if there's a change in the administration at the federal level and a change in who is the FDA commissioner, there may be renewed efforts.
So let me turn to some of the other consequences of the Dobbs decision, including the concerns that it may have implications beyond abortion. If you could maybe talk for a minute about the recent legislation passed by the Senate.
Sure, that would be great. It would be nice to have some.
And the House, I should say, the legislation that was passed by the Senate House and will be signed.
Yeah, will be signed by the president shortly. So one of the realities of the Dobbs decision is that when the Supreme Court reversed Roe, although they said that this case is only about abortion and has no bearing on any other rights that are in this sort of similar kind of constitutional lineage, there were a number of other cases. Roe didn't emerge sort of on its own. It built on earlier non-abortion cases, and Roe in turn was then used as a precedent for other rights, such as the right to same-sex marriage. While the court in Dobbs said that Dobbs does not have any bearing on these other rights, the analysis that the court took in Dobbs significantly erodes the constitutional underpinnings of some of these other cases. And almost immediately upon the Dobbs opinion, the Respect for Marriage Act was introduced at the federal level in the House. The Respect for Marriage Act was an attempt, I think, to secure some of the rights closely related to same-sex marriage. There was a statute that Congress passed in 1996 when Bill Clinton was president called the Defense of Marriage Act, or DOMA, that for the purposes of all federal laws and policies defined marriage as a union between one man and one woman, and also said that no state need recognize a valid same-sex marriage that was entered into in another state. Although DOMA was deemed unconstitutional and struck down in 2013, and it's also part of the same family of cases, DOMA was never repealed. It sits there on the books. The Respect for Marriage Act repeals DOMA and precludes some subsequent legal challenge from reviving DOMA. So it now requires that all states give full faith and credit to any valid same-sex or interracial marriage that was entered into in another state. And for the purposes of all federal laws, a valid same-sex marriage will be recognized federally. So it's some good news.
That's some good news, but there always seems to be some bad news along with any good news. I saw that you recently had an article in the Journal of the American Medical Association, I believe.
I did, yes.
About other potential consequences that could flow from Dobbs. Do you think that this law that just passed kind of resolves all those questions, or do you think we're going to have to see?
I think we're going to have to see. So it's a very similar issue to what the Respect for Marriage Act just did. It was reversing DOMA just to make sure that there couldn't be attempts to try to revive DOMA. The article that Dr. Chris Beyrer and I published in JAMA was looking at what might happen to a case known as Lawrence versus Texas, also in the same sort of kind of due process protective cases. This was the case that provided a constitutional right to same-sex physical intimacy. And just as there were many pre-Roe abortion bans that were invalid but never repealed after Roe, there were 12 states that had pre-Lawrence sodomy criminal laws that were never repealed after Lawrence. So they're invalid. They have no force or effect, but they're still on the books. And we wrote this article to make clear that even though these laws are invalid, they're still lurking in state codes. And Dobbs has opened the door to potentially revisiting Lawrence as well as other precedents. And so the safest course would be to repeal those laws and take that argument off the table, much in the way that the Respect for Marriage Act has repealed DOMA and taken any attempts to revive it off the table.
So still a lot of issues out there, still a lot of work to do for those of us interested in protecting the right to privacy in different domains here.
Indeed.
I very much appreciate your joining us, and I'm sure we'll find more to talk about in the months ahead.
Great. Look forward to it, Josh.
Public Health on Call is a podcast from the Johns Hopkins Bloomberg School of Public Health, produced by Joshua Sharfstein, Lindsay Smith Rogers, and Stephanie Desmond. Audio production by J.B. Arbogast, Holly Cardinale, Philip Porter, Spencer Greer, and Matthew Martin, with support from Chip Hickey. Distribution by Nick Moran. Production support from Catherine Ricardo. Social media run by Grace Fernandez and Shian Briscoe. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes. Thank you for listening.